And one of our main topics today is non-liability of network intermediaries. What can you say about this principle? Which are the main constraints you see with the implementation of laws dealing with this type of role?
Let me start off by giving an example of what can go wrong. And that would be the example of the Indian government and the laws that we put in place a few years ago with regard to intermediary liability for third-party content. What the government essentially did was to set up a system through regulations that allowed any person to complain to an intermediary about any content, even content that in many cases are actually valid under Indian law. Okay. One example that crops to mind is that of disparaging speech. So disparaging someone is not illegal under Indian law, but that was one of the grounds that was listed in the regulation. So it allows any person to complain to an intermediary about any content, including content that is perfectly legal under Indian law, on 48 different grounds, if I remember right. And the intermediary would have to remove that content within 36 hours. If it did not, it essentially opened itself up to liability for that content. Now, companies are risk averse, which means that if something potentially will land them in trouble, because there's so much speech on the internet, your post about the ongoing troubles in the political landscape in Brazil is expendable for them. Right, so if I complained about that and you were in India, they would remove it. And there was complete lack of transparency. So we don't know how many complaints were filed under this law. We don't know how many times companies complied with takedown requests. We have no idea what was taken down, whether it was legitimate content, whether it was illegal content. We have no idea whatsoever. The only way that we could study it in India was to ourselves file takedown requests and to see what the companies did. So we did that. We filed 7 fake, fraudulent, frivolous complaints. Complaints that should not have gotten any company to remove any material. What we found was that in 6 out of 7 cases, the material that we'd complained about had been removed. So we sent to search engines, we sent to, in one case, a newspaper. We complained about one comment under a particular article. And what they did was remove all 15 comments that were on that page. And this was a perfectly legitimate comment. It wasn't even borderline or anything. It was perfectly valid speech, protected by the constitution in India. And yet they were risk averse and they removed all the comments, even things we didn't complain about, they removed. And so that is why the issue of intermediary liability is such an important issue when it comes to freedom of expression. That if you don't protect intermediaries from liability for third-party content, then a lot of legitimate speech will also be removed because corporations are risk averse. And the largest ground in India for content blocking is copyright. And that's a large problem because what we saw in India was that a variety of different services, I remember pastebin.com, which is a text pasting website, was blocked for violation of copyright in films. GOO.gl, which is Google's URL shortener, that was blocked. Vimeo, Meta Cafe, various video hosting websites were blocked. And how is that possible without a particular complaint of one link where, some unlawful material is being hosted? Because these were all blocked before the release of the film, for which, there were copyright complaints. So the film hadn't even been released, and yet preemptively websites were blocked. Again, it's an unfortunate situation where one piece of advice that lawyers gave to that Azerbaijani journalist I spoke about, Khadija, was to actually file a copyright complaint. To say that, no, privacy doesn't matter, but if you want to get that video removed, file a copyright complaint and it'll be gone. So there's a complete breakdown of a sense of proportion when it comes to laws, where laws that matter to corporations for maximization of profit, those become important and strongly enforceable. And again, why is this a situation? Because a particular law in the US exists. So the DMCA is not globally valid, but people in India, if you ask them, they'll cite the DMCA. They'll talk about, they'll talk about fair use. They'll talk about things that don't exist in Indian law because that is their perception of the law as applies to them. And they aren't wrong because the DMCA does apply to them. Their videos which they post on YouTube can be removed because of DMCA. Yeah. They can get something else removed from YouTube through a DMCA complaint. So these laws are universally applicable because of American corporations.
And based on DMCA, millions of content pieces are removed every day from the search engines and from hosting services by the copyright holders, based on copyright holders' complaints.
That wouldn't be a problem if we had a situation where there was some way of ensuring that those were only the most genuine requests. But as I showed through the Indian example, and this isn't unique to the Indian experience, that these aren't just genuine infringing material that is being removed. And there's this complete lack of transparency, this complete lack of information that further worsens the problem.
And what are your views about the Manila Principles on Internet liability? What are the difficulties embedded in it so it can turn out something more tangible by the law point of view, even national or international?
So just a little bit of background on the Manila Principles. The Center for Internet and Society was very closely involved in framing these principles, in bringing together a variety of civil society organizations and NGOs across the world. And currently more than 90 such NGOs have signed up to these principles. The Manila Principles document contains two kinds of directives. One aimed at governments and states when they are formulating their laws and regulations around the issue of intermediary liability. But they also look at corporations and their policies and practices for content removal. And it tries to evolve a set of principles that can be used by both states and by corporations when they want to ensure that a proper balance exists between freedom of speech concerns and between the need to be able to react to valid requests for removal of content as well. So that's a very large framing of what the Manila Principles do. There are 6 such principles, and there are multiple countries that right now are reforming their laws around intermediary liability or are introducing new laws around intermediary liability, to actually cite that and to say these are a set of guiding principles that can be used while framing our national laws. And that's already being done. Slowly they're getting that kind of currency in policy debates, and that's essentially how to get them used by governments. And slowly, because parts of the principle deal with due process when it comes to corporations and about transparency requirements of corporations that they need to adopt, slowly it's being used there as well. In terms of the deficiencies, I think there are some clear difficulties. The main one is that when we're talking about intermediaries, it's very difficult to know who we're talking about, because intermediaries can be everything from your domain name provider to your web host, and even within web hosts or ISPs there can be really large ones or really small ones. Now that presents a little bit of a problem, or a little bit of a challenge. Now the majority of the principles actually talk about content hosts. So don't deal with ISPs, which shouldn't be having any liability. Don't deal with domain name providers, which shouldn't be liable for the content, etc. So they deal primarily with that. But even within that, the larger companies ought to bear a greater responsibility. A Facebook ought to bear greater responsibility and duties with regard to, say, transparency requirements or with regard to due process requirements than if you're providing a service for a few of your friends. And that doesn't get captured well enough, because it's very difficult to capture that in a broad level principles document that you're trying to keep short and snappy, right? It's very difficult. And one way that we've tried to do that is to, in some places, say that the intermediaries must, and in some places saying the intermediaries may, and to allow for a little bit of flexibility in some cases where smaller intermediaries may not actually need to do as much and wouldn't be harming people's rights if they didn't comply with certain things. So one is that problem always exists. The other issue, and I don't see this necessarily as a failing of the Manila Principles, but to bring up one other issue is that they deal primarily with content of different sorts and liability for third-party content. But what about other kinds of things? What about, say, when a denial of service attack is happening? At that time, should we make an intermediary liable if it fails to actually take action within a reasonable time frame to prevent that from harming other networks? So this doesn't have any grave free speech implications, and this is a kind of liability that we may well want to consider. But this wasn't part of the focus of the Manila Principles, because those were focused on rights and focused on ensuring that freedom of speech and expression and privacy and freedom of association, etc., are also protected online. And given the fact that you have to go through intermediaries and to be part of the internet, and they must have some amount of protection.
Should we allow national governments to apply their own national legislation, even in the case of when the national and the local legislation are in conflict with these human rights standards?
The United States of America, which is seen as a bastion of freedom of expression, does not comply fully with the ICCPR, the International Covenant on Civil and Political Rights, on Article 19, which is the article on freedom of expression and opinion. Should we say that that undermines the US on free speech grounds? In India, we have a situation where the Supreme Court essentially has held that if India has ratified a treaty, then we can read parts of that treaty as part of Indian law. So in India, for instance, we can directly apply through the court system treaties as well. We can directly cite treaties even if the government hasn't passed a law implementing that treaty. When these kinds of situations exist in parts of the world, and at least when a government fails to live up to certain human rights standards, those actions, often in violation of the nation's constitution or Bill of Rights or similar documents, can be challenged in a court. So if the government does not fulfill its human rights obligations, those at least are challengeable in national courts. Here in Latin America, I know there is a robust system with the Inter-American Court that even internationally, there is at least a process through the Human Rights Council for universal periodic review of different countries and their implementation of their human rights standards. At least these kinds of processes exist. But when it comes to private corporations, I can't, if they violate human rights, and as I said, online, they become much more important players in terms of governance than they are offline. Much more important, I think. If a corporation violates my human rights, to whom do I have recourse? Right? And some corporations, and now it would be unfair, of course, to say that a corporation, for instance, to equate if you're providing some services to 10 of your friends, then if you arbitrarily say to one of them, no, I'm not going to provide services to you anymore, that's not a violation. But on the other hand, if a Facebook, which is larger than most countries, it is right now, I believe, only second after China in terms of the number of people its laws.
Believing that.
Yeah, it's in a sense laws apply to. Well, if Facebook does not provide some kind of fair process for its terms of service and its evaluation, if it arbitrarily kicks people off, if it doesn't allow them the right to have their own name, then where do you go? What do you do? So there is that problem as well. And it's unfair to pick only on governments when looking at this, because it's a problem not just with governments, but it's a larger problem that we have, and governments must be seen as part of the solution rather than only part of the problem. They are definitely part of the problem. So I agree with the initial laying out of the question as you did. But they should also be seen as part of the solution. Now, one of the things, because the laws are different in different countries, one of the things that we necessarily must have is governments acting in an enlightened way and saying that part of what we consider our sovereign rights currently, also we will have to cede in the global public interest for something, for the governance of the internet. So one example of that I can think of is with the domain name system, what are called the root servers, right, where which are the ultimate authority for what a .in should actually means in terms of IP, and what a COM should actually point to. And these root words, which are the ultimate authority on this. And there's something called IANA, which, as part of its process, actually controls, is responsible for, rather than controls, is responsible for the root zone file. We can't allow a government which has sanctions, say, against South Sudan or against North Korea to say, okay, because of those sanctions which are in place in the US, because currently the IANA functions operator, something called the root zone maintainer, which is VeriSign, all of these are located physically in the US or are subject to US jurisdiction. You can't allow US sanctions to affect a request by the North Korean government to change what the root zone file says about their CCTLD. We can't allow for that. So we do need some kind of international consensus that, regardless of whether it is war, regardless of whether it is sanctions, regardless of what kind of situation it is, that there will be immunity for core internet operations. And governments need to cede some of their, what they see as their sovereign rights for the greater benefit of the internet, for the greater benefit of the world. We haven't yet gotten there, unfortunately. We've gotten there in some other areas, such as trade. Right? We see these mega trade treaties, which are coming now, plurilateral treaties coming up after the multilateral WTO system came up. And now that developing countries are asserting themselves at the multilateral system, developed countries have shifted to the plurilateral system, having a smaller select club and then hoping to force other people to act by the same rules. So it's worked out where some amount of sovereignty is ceded by different countries to be part of the trade system. But in other kinds of areas, in internet governance, it hasn't yet. And one thing that really frustrates me is the slow pace of change. Right now, this week, in New York at the United Nations, there will be the World Summit on Information Society plus 10 review, the review after a decade of the functioning of the original plans laid out, the agenda laid out during WSIS in 2003 and 2005. So many of the same internet governance issues from that time remain exactly the same now, remain exactly the same today. The European Court of Human Rights recently struck down the safe harbor agreement between the US and the European Union, which essentially meant that there couldn't be free flow of data between the EU and the US. Now, this is the same set of issues, the same set of jurisdiction issues that were being debated at that time in the early 2000s. In 2005, the US government had said that by 2006, we will have a transition of IANA functions from US control. In 2015, the US government is saying by 2016, we'll have a transition of IANA functions from US control. Everything, the more you look at it, looks to be exactly the same. That's a real pity that over so many years, over more than 2 decades, we've progressed so little when it comes to issues such as jurisdiction. And lest we look at at governments as only things that try and curb rights, well, we wouldn't have consumer rights. Were it not for our ability to go to a court and enforce those rights against corporations. And we've given ourselves consumer rights through governments. Now, because of the internet, Indian consumers essentially can't enforce their rights against American corporations, which aren't based in India, right? And when we go to Indian courts against US corporations, they essentially say, oh, you've got the wrong party. We here in India are only the marketing arm of that global company. So any kind of request you have to send to them. Now that leaves Indian consumers unable to enforce their rights. What do we do about that? There's been no concrete breakthrough on these kinds of issues in the last 20 years. And forget about a breakthrough. I don't think magically things will improve. But has there even been some kind of gradual progress? And I don't really see that having happened, and that's an unfortunate source of cynicism for me, that things might not actually improve all that much through the regular processes of law and regulation, which is what we're here to discuss this week.
The developing world is not represented or well represented in that discussion. Oh, there's a lack of balance.
There is, even if there is some representation, there is absolutely no power. Internet governance is determined by American corporations and to a lesser extent by European laws like data protection laws. Other than this, and because EU data protection laws are what they are, because they formulated in a way to say that unless other countries also match up to our laws, we won't be able to send out Europeans' data to them. Because they managed to do that very early on in the 90s, and because Europe is a major trading partner for different countries that want outsourcing, like India, the Philippines, etc. All of us essentially try to mirror our laws with European data protection laws, because that's a requirement of their law. And de facto, that becomes the law for the rest of the world. And de facto, the rules set by Google and Facebook and companies like this, which are humongous, and Apple, etc., that becomes the rest of the internet governance laws. So where's the space for the rest of the developing country? And the only way this, at ICANN at least, can change is if the business constituency at ICANN, those who are involved in the registries, the registrars, the vast majority of registries are still US-based. And the only way to change this is to allow for new entrants to upset the older players. That's not going to happen by what ICANN did, was to expand the number of what are called generic top-level domains, right? GTLDs, which essentially are things like .com, .net, etc. Now, those have been opened up, as you know. The newer entrants who've flooded that space, again, have been mostly Americans, mostly established companies like Google, Amazon, Newstar, VeriSign, and Affilius, etc., rushing in. Now, and with newer, different GTLDs, they're never really going to make a mark for themselves. Maybe some 15, 20 of them might survive in the long run, not the more than 1,000 who have actually applied. What we need to be able to do is upset the apple cart of .com, of .net, of .org. Why aren't those ever going to go out of American hands? Why hasn't .com ever been put out for open bidding the way the GTLD process was done? Why is VeriSign guaranteed .com forever and ever? There's presumptive renewal in the contract between ICANN and VeriSign. Why is that? Right? It's only if you allow a Brazilian company to bid for the .com contract, to essentially say that, no, we will operate the .com now, okay, and we'll do a better job of it than VeriSign has been doing, that you'll actually be able to change the way the internet is run. I don't see that happening anytime soon.